Hello everyone, this is Shreya Tripathy. I'm a research fellow with the JALDI initiative at WITI. Joining me today are Mr. Sushant Sinha, founder of Indian Carnot, and Mr. Prashant Reddy, a lawyer who was formerly the lead of the JALDI initiative. He was also the lead author on WITI's report on open courts in the digital age, which we would be discussing today. Now, during the COVID-19 pandemic, the courts in India were almost extremely forced to become digital. This essentially led to many different conversations about the digital infrastructure and open courts and open data in general in the country to start, and also happened parallelly. The open courts movement in India draws on the principles of the open government movement, which in turn draws its principles from Section 4 of the RTI Act. In terms of the judiciary, the digitization efforts of the E-Committee of the Supreme Court has resulted in the judiciary as well as the Ministry of Law and Justice collecting vast quantities of judicial data. However, the lack of an open data policy has also meant that the data that is being collected is not being disseminated meaningfully. And hence, this is also leading to there being like a lack of transparency and accountability for the judiciary. So, to begin with, I would like to ask Prashant, why should the Indian judiciary have an open data policy and what exactly would that entail?
Thanks, Shreya. So I think, one of the reasons that, we were very enthusiastic about writing that report on why the courts need an open data policy is because it may finally provide a solution to one of the oldest problems faced by the Indian judiciary, which is a lack of accurate statistics and data. Even today, with the e-courts program and the National Judicial Data Grid, we still can't access the kind of data that is required to propose any kind of meaningful reform. Which is why the Supreme Court, if it adopts, an open data policy, which means that making all of its data machine readable, not just its data, I mean the entire e-courts program's data, not only machine readable, but all the data needs to be neatly tagged and identified so that and provided access to. So if the Supreme Court, the E-Committee did hint at this earlier this year, that they would provide API access to outside parties to access this so that they can access all of this open data. Because if the judiciary hasn't been able to, compile these statistics and release it properly, perhaps if they if they adopt an open data policy where the data is neatly categorized and labeled, and they open it up for third parties, the hope is that third parties like Sushant will be able to come up with more innovative apps, identifying where exactly are the problems with the judiciary's working. Once we have access to data, we will be able to point out where exactly their backlogs, which courts are suffering from an excessive load. So that kind of data would be very, very useful. And it's also in sync with the government's own national data sharing and accessibility policy, which the Department of Science and Technology had put out long ago, which basically drew on the same principles from the RTI Act, Section 4 of the RTI Act, with the understanding that any publicly funded data should be made available to the public. So this is not just an abstract policy issue. This flows from a constitutional requirement of sharing information, and it's the Supreme Court which has interpreted the Constitution in this manner. So it's rather ironic that the Supreme Court is doing very little to adopt an open data policy for the e-court system, which could solve a lot of problems.
Thank you so much, Prashant. So from that, as you rightly said, we would like to understand from Sushant, like why even like a third party repository like the Indian Carnot came up, like what was the thought process behind it. And also we would like to understand like what were the technical issues that you used to encounter when in your earlier years when you were accessing data from different court websites, and how has you changed that, how have you seen that evolve or change over the years?
So I started Indian Carnot. My purpose that time was to only make a search engine for Indian law so that common people can figure out what is the law on a given issue is. So you just type a query and can get what the law is. And I started, I mean, that time the Supreme Court started opening its court judgments. Some high courts have also started at that time. But the problem was that at that time that only we could only get orders for a very few years. The courts were not having their full orders themselves, and most of these were hidden behind paywalls. So to get a full coverage of court cases was very difficult at that point. And then I had to actually fetch from multiple sources to make sure that the data is complete till the point Indian Kanoon was started. And so that was a major challenge of just aggregating data from all the sources. My main point was actually to build a search engine. I did not start with figuring out that I need to do data collation as well, which actually proved to be a bigger challenge than just building the search engine itself. I mean, search engine itself is a pretty simple thing in the sense that court judgments are ranked based on their relevance, and their relevance is determined by how much they are cited by and some other factors like court order length and things like that. But I mean, this the relevance has mostly worked out well. The data incompleteness was the big problem in the starting one. And even now, if you see, most of the court websites do not have their full catalog of their judgments. It was only the third-party providers who have all the full set of judgments. I mean, of course, Indian Kanoon may not be the best one in the business, but we actually have now more than 1.6 crore court judgments just from the High Court and the Supreme Court. So that's as perhaps the biggest set, I think. I don't think anyone else has, because other people don't even take the daily orders and things like that, other providers. So one of the problems I have realized over time is that the biggest problem that we have is that there is no open data policy by the courts themselves. And as Prashant has rightly said, absence of that data policy means that there is no implementation of it. No courts are keeping on what data needs to go out and what data needs to be published. The court websites are kind of non-functional in many ways because they do not even have the full catalog of orders. I mean, so if you are a lay person who relies only on the court websites, you can't even rely on that. So, and the second problem that comes with is the pleadings. The people file affidavits, people file their applications, and none of this is available right now. So you can have an order which says the order is dismissed, but you do not know what was even pleaded in the application and what even the reply was given by the opposing party. So all that is hidden under court policies. There is no standardization of these court policies. And most of the time, you cannot get these documents until you actually visit the court yourself.
Even then, you can't get the documents. No, because that's one of the issues that we cover in our report, where the way the court rules have been drafted, you can't access half these documents even if you visit court during the pendency of the suit, and after the suit is disposed, even then trying to access it is so difficult. And all of these pleadings are being discussed in open court in any event. So God knows why the judiciary treats it as, so confidential.
Yeah. So from this, yeah, sure.
So, I mean, one problem that people keep throwing up is some kind of privacy is needed for pleadings. And that has not been dealt with correctly on what should be the redacted and what should not be redacted. There is no data policy to cover those grounds. And because of that, the whole treasure of the pleadings is actually hidden from public view, even if they are public documents.
This was actually my last question for you, Sushant. Like, what are some of the issues that Indian Kanoon has faced in terms of like privacy of parties, right? Like, and like some of the issues that you think that will come in the future, considering that we are like the Indian judiciary is making an attempt to make everything digital. So, as it plays out in the future, how that will change? And even Prashant, if you can weigh in on that.
Yeah, I mean, see, the whole problem with the open data without a policy is most of the steps people take are kind of an ad hoc way. So one example I'll give you is court gives an order for redacting names of some people in a court judgment. What the court does, what the court registrar or the court website does, it completely deletes that document. See, the court order was not to actually delete the document from your website. The order was to actually remove the name and remove any linkage it has from the search engine, right? So what that means is that without a good data policy, without a good retention and redaction policy, even if there is a good order to be implemented, it cannot be implemented correctly. Now this is another big problem that comes is regarding the set of updated laws and regulations. So that problem mostly comes because government does not supply up-to-date version of laws or regulations to the common public. Most of the time, it is pieced together by various publishers, which is actually in the end lawyers rely on in the court to say what is the actual law on a subject is. And I mean, the actual law on the subject is also fairly complicated in the Indian context because the law is framed and the regulation is framed. Then the amendment to a regulation can also be done by just changing a few words here and there through a gazette notification. And until unless you track all of these, you have no idea what the standing law on any issue is. So I think India could try to do it, fix some of these things, but of course, I don't think they are doing it in a correct way. Again, because they are not using a correct data framework to do it, which is why I started the laws.indiancarnot.org project, which actually now catalogs all the laws and regulations into a common Akuma Natoso framework. So we can track all the changes over time and things like that. I mean, that project is not yet fully done, so you don't see that on Indian Kanoon yet. But once that gets done, you will see more of it.
Yeah, I'm sure that will be even more of a savior for Indian law students. But yeah, Prashant, if you want to add.
Yeah, on the privacy aspect, I think it's a relatively easy issue to solve because we know what kind of private information is likely to be shared in court documents. It's mainly bank account numbers, say phone numbers, other issues like addresses. It's contentious whether your address is actually private or not, because other people are bound to know your address for a variety of reasons. And there, I think that, if the Supreme Court just put it back into it, it could easily come up with a privacy policy which will, just anonymize all these kind of details, like the central 5 digits or 6 digits. You can just anonymize them and keep everything else open. So that, I don't think it's a difficult nut to crack. The problem that I foresee is a privacy exception is going to be abused in a country like India to the hilt. So traditionally, we've seen, for example, income tax cases, income tax litigation, nobody has ever asked for any kind of anonymization, whether it's companies or private people. And your income data, your financial data, all of this is being discussed. The tricky part, I think, is when you start discussing privacy, forget the corporations. Corporations don't have a right to privacy, but a lot of rich individuals are the most likely candidates to try and use privacy to cover certain aspects of litigation which they don't want greater public access to. So that is something. It's going to be very difficult to actually implement a privacy policy, and we're very likely to see, the exception becoming the rule very fast. That's my fear with privacy. And a country like India, right now, we're at a stage where you need transparency a lot more than you need privacy. There's certain protected categories like sexual assault victims, etc., where definitely there is no question that privacy is required. But given the scope of privacy, we don't know how far it's going to expand, because it has to be loosely defined, and then the exception will start becoming the rule. On the second issue that Sushant spoke about on India Code, he's right. I mean, so India Code, after this, there was a series of litigations which had started with some student, I think at Nalsar or NLS, I'm not sure where, which went through the CIC, which went to the Delhi High Court. And then the Delhi High Court basically held the Ministry of Law at gunpoint and said, you have to disclose all these laws on India Code. So they've disclosed all these laws, and then they put up a massive disclaimer saying that we don't stand by the accuracy of any of this information, which basically renders it completely useless if you're a lawyer or private citizen wanting to use this. And I think there's a case, maybe Sushant could be the litigant where he sues the government, saying that you have a duty to provide accurate information under the RTI Act. You just can't put out all this information and then put out a disclaimer saying that, oh, we don't guarantee the accuracy of any of this information. Back to you, Shreya.
Another resource that we do have currently is the eCourts website, which acts as a repository for data with regard to the high courts as well as district courts. And the eCourts website also carries some judgments and orders that have been delivered by the district courts in India. So Sushant, could you please give us some insight into the data that is being uploaded on the eCourts website and about how usable this data is?
So the orders from subordinate judiciary are also very important, and currently Indian Carnot database lacks it. The only two places where we catalog the decisions are from the Delhi district courts and the Bangalore district courts. The Bangalore district courts, we only cover up to, I think, 90% of the orders, because 10% of them are in Kannada. And that is a problem, because many of these PDFs are not using Unicode language. And once you go down to the subordinate judiciary in other states, you move out of the metropolis, you have mostly the orders written in actually the local languages. And the local languages they should be done using something that supports Unicode and a way so we can process the data. But many of them actually use proprietary fonts. So we cannot index them directly, because they will look, without the fonts, they will not look like even characters, proper characters. So that is one major problem with all the district court orders, which is why we in Indian Kanoon right now are not able to add all that subordinate judiciary. And actually many of the problems that do not go to the higher judiciary, and it is dealt by the subordinate judiciary itself, especially the criminal trials or a civil suit. So those things are usually, so certainly Indian Kanoon lacks that, and the eCourt website doesn't solve that problem entirely, because they still don't have an open standard way of doing local languages correctly.
To read the report, Open Courts in the Digital Age, a prescription for an open data policy, visit the Vidhi website.